Hello and welcome. Today we will be educating you on the unconstitutionality of COVID-19 mandates and regulations.
More specifically, the relevant problems of business closures and limits on group gatherings.
Excuse me, ma'am. This premise is closed due to Public Health Order 2022.
No! How will I feed my children? What about my rights?
Actually, the Governor, His Majesty Jared Paulus, has declared a state of disaster emergency that will continue until he finds that the threat has passed or has been sufficiently dealt with. But no state of disaster emergency may last longer than 30 days unless the Governor renews.
Sorry, but doesn't that mean the Governor can just keep renewing whenever he wants?
There is a check in power, actually. The General Assembly, at any time, by joint resolution, may terminate the state of disaster emergency.
What the heck is a General Assembly?
That's not important.
The General Assembly is a bicameral state legislature that was created by the 1876 Colorado State Constitution. It is made up of 35 senators and 65 representatives.
Thank you, oddly informative disembodied voice. The distraught mother we just saw does indeed have a good point. What about our constitutional rights during a global health crisis? Before we jump into the specifics of the constitutionality of business closures, let's review the powers of the state government during a crisis such as a pandemic. As we were informed by that extremely informative interaction back there, the Colorado governor has something called disaster emergency powers under the Colorado Constitution. After the governor declares a disaster emergency, the governor may issue executive orders, proclamations, and regulations, and amend or rescind them. States also have police powers under the 10th Amendment of the U.S. Constitution. The 10th Amendment states, "The powers not delegated to the United States by the Constitution, nor prohibited by it to the States, are reserved to the States respectively, or to the people." In the case Jacobson v. Massachusetts, 1905, the Supreme Court upheld the authority of the state of Massachusetts to enforce compulsory vaccination laws during the smallpox outbreak. According to the court in this precedent, states may implement emergency mandates and measures during times of emergency that are extra-constitutional, meaning a state may implement measures that curtail constitutional rights as long as they have an actual or considerable relation to the public health crisis and are not blatantly a plain, palpable invasion of inalienable rights. It is important to note that the Supreme Court did observe that if a state exercises police powers of the state and implements measures that are so arbitrary and oppressive, that would justify the SCOTUS interfering. So although states have the power and authority to enact public health measures, health mandates and regulations can definitely violate the Constitution. People have cited Jacobson v. Massachusetts as support for deference to state authorities concerning matters of health and safety. However, 116 years ago, there wasn't the more refined modern jurisprudence that we have today, such as the levels of scrutiny. So the Jacobson case is not as instructive when applied to modern cases. Normally today, matters of civil rights or questions of constitutionality would fall under strict scrutiny because they constitute a compelling governmental interest. However, one might argue that a suspension of traditional levels of constitutional scrutiny in reviewing challenges to COVID-19 health mandates is appropriate. In order to justify softened standards of review, the crisis should be brief and finite to avoid exploitation of the situation. Because the coronavirus pandemic will go on for an indefinite amount of time, softened standards of review for the constitutionality of mandates and regulations may not be fitting. The judiciary must be free of influence if traditional scrutiny is suspended. The Supreme Court must be able to push back against overreaching COVID mandates. Unlike in the precedent of Korematsu v. U.S., where there was questions of individual liberty versus national security. In Korematsu v. United States, the Supreme Court validated violations of civil rights because they were unwilling or unable to meaningfully look behind the government's alleged claims of urgent need or demand for public security. The case Butler v. Wolf found Pennsylvania public health orders pertaining to business shutdowns during the coronavirus pandemic as violations of the 14th Amendment. The court found the health order describing business limits to be not narrowly drawn enough. They also found that the shutdown of all non-life-sustaining businesses was unprecedented in American history, and that the right of citizens to support themselves by engaging in a chosen occupation is deeply rooted in our nation's legal and cultural history and has long been recognized as a component of the liberties protected by the 14th Amendment. But that's Pennsylvania. Will the Colorado mandate on business closures and limits also be found unconstitutional? One of the things that the court in Butler v. Wolf found was that the mandates were not narrowly drawn. They had obtuse language. With the Colorado Public Health Order 2022 pertaining to business closedowns, we see acute language with specific exemptions. According to the precedent Jacobson v. Massachusetts, emergency mandates and measures during times of disaster emergency are extra-constitutional. In light of the coronavirus pandemic, measures for the mitigation of the virus can curtail constitutional rights as long as they are substantially related to the public health crisis and are not a plain palpable invasion of inalienable rights of life, liberty, and property. However, restricting or shutting down the means of a person's livelihood most certainly is a deprivation of inalienable rights. Arguably, Colorado Public Health Order 2022 about closing down businesses violates the 14th Amendment, which guarantees a citizen's right to support himself by pursuing a chosen occupation. And the Due Process Clause of the 14th Amendment includes an important section that bars arbitrary and/or wrongful government action regardless of the fairness of the procedures used to implement them. The Due Process Clause of the 14th Amendment also says that no state shall make or enforce any law abridging the privileges or immunities of citizens of the United States, nor deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. According to the Colorado Constitution regarding the governor's emergency powers, the governor's executive orders, proclamations, and regulations have the force and effect of law during a declared time of disaster emergency. And one of the points in the Due Process Clause is that no state shall make or enforce any law depriving any person of life, liberty, or property without due process of law. As discussed before, depriving someone of their income is depriving citizens of their inalienable right to life and liberty. Like we saw earlier, many people like that worried mother were negatively affected financially by business shutdowns and would potentially struggle to support themselves and their families. This brings into question again individual rights versus public security. The right of citizens to support themselves by engaging in a chosen occupation is one of the liberties protected by the 14th Amendment, and, as noted in the Butler v. Wolf case, the shutdown of all non-life-sustaining businesses is unprecedented in American history. In summary, the Colorado governor has emergency powers under the Colorado Constitution. States also have police powers under the 10th Amendment of the U.S. Constitution. According to Jacobson v. Massachusetts, states may implement mandates and measures during times of emergency that are extra-constitutional. However, these have to have actual or considerable relation to the public health crisis and cannot be a plain palpable invasion of inalienable rights. Scrutiny. Normally, matters of civil rights or questions of constitutionality would fall under strict scrutiny. However, suspension of regular levels of scrutiny when examining the constitutionality of coronavirus mitigation measures may be appropriate. For it to be appropriate to implement softened levels of scrutiny, the crisis should be brief and have a finite end so that the situation is not taken advantage of. Applying this to the situation, the coronavirus pandemic does not have a definite end. The judiciary must be free of bias and influence if traditional scrutiny is suspended. Otherwise, we might end up with a situation like Korematsu v. U.S., where the courts validated violations of civil rights because they applied their biases when they were enforcing public security measures. In Butler v. Wolf, the court found that Pennsylvania public health orders about business shutdowns were unconstitutional. The limits were not narrowly drawn. The shutdown of businesses during a pandemic was unprecedented in our nation's history, and they violated the 14th Amendment right of supporting oneself by engaging in a chosen line of work. With the Colorado business closure order, we see more acute language, but it still violates the 14th Amendment right to pursue a livelihood and due process clause. Business closure orders are also a violation of the inalienable rights of life and liberty.
Come on, kiddos.
Wait, I don't see you on the list. Did you make reservations?
Make what?
Sorry, ma'am, you can't come in without reservations.
Since when?
Since His Majesty, Governor Jared Polis, passed the latest executive order that prohibits public gatherings of over 10 people.
So only 10 people can go to Mass today? But this isn't even a business. This is my religion. Don't I have the right to practice it?
Yes, but just do it at your house.
That's not how it works. Going to Mass in person is essential to my religion.
Then you should have made reservations.
But even then, only 10 people from my church could go to Mass. Hundreds of people would be deprived of the religious freedom.
She's right. We should get people together to protest this. No gatherings with more than 10 people.
So, here's a tricky one. One of the most crucial parts the U.S. government plays is protecting the freedom of religion, speech, and assembly. That's why we have the First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances. Let's start with religion. The First Amendment's goal is to essentially keep the government out of religion. Forcing churches and religious groups to close down or limit the amount of people able to attend goes directly against the First Amendment. Of course, this is where we have to consider the emergency powers of the governor during a pandemic. The governor's stay-at-home orders and business restrictions were not meant to target religion. His orders generally referred to all public and private places. However, the executive orders did always have the exception of essential businesses. Religious organizations were not included in this category. According to the First Amendment, religion is a natural right. Therefore, it should have been considered essential and allowed to stay open to the public. Additionally, restricting the number of people allowed to attend their religious services would inevitably mean somebody doesn't get to attend. That would end up taking away some people's religious freedom instead of specific individuals, which is still an infringement of rights. On the other hand, it could be argued that a large number of people gathering under any circumstance during this pandemic endangers other people. This would invalidate the freedom to practice that part of the religion that is harming others. For instance, if somebody practiced a religion that required murder, that person would no longer be free to take part in that aspect of his religion and would be arrested if he did. People meeting for a religious gathering is not directly or necessarily taking the life of anybody, and the participants are not forced to come. The people attending would be taking their own risk of getting sick, which wouldn't necessarily mean death or harm to others. Next up is freedom of assembly. This right was included in the Constitution in the first place because the founders knew how important it was to be able to push back against a corrupt government. The people's strength comes in their numbers, so the primary goal of a dishonest government would be to keep people apart. It would seem like the recent restrictions that have been placed over the gatherings due to COVID would violate the First Amendment. However, when questioning if an order is unconstitutional, strict scrutiny, due process analysis is needed. Gathering restrictions do impede on the exercise of this right, so now we need to ask if the orders intend to achieve a compelling government purpose. Orders pertaining to assembly restrictions are meant to protect public health from the COVID-19 virus, which has been declared as a pandemic. Therefore, these orders are meant for a compelling government purpose. The final question to ask is if there is a less restrictive way of achieving this. This is where the issue gets complicated and can be looked at in more than one way. The answer depends mostly on scientific knowledge, and since there are no set and widely accepted facts about effectiveness regarding COVID regulations, it is hard to form the right solution. It could be argued that since masks are already required for gatherings, other restrictions that prevent people from assembling are not necessary. Likewise, some may debate that stopping gatherings doesn't help the public against COVID, but is only weakening people's immune system and putting them in more danger for the future. Others could argue that masks are not enough to achieve the goal of public health, and gatherings should be strictly limited. Which side of the argument is correct determines whether the orders should pass the strict scrutiny test or not. Even if a court decides on which side it will take, does not mean that they could make a mistake on their decision and regret it in the future, because their decision was ultimately unconstitutional. This has been seen many times, such as in the cases of Korematsu versus U.S. with the Supreme Court.
So today, we went over an overview of the arguments that point to either the constitutionality or unconstitutionality of business closures and gathering restrictions, depending on how you view the facts.
And that's a wrap. Thank you so much for watching, and we hope you have a blessed day.